I will go ahead and call this next case, which is People versus Clifford and Rodney McKee. Mr. Halpern and Ms. Sharon, I assume you have sorted out how you will use your time. Each side has 20 minutes, and you all may attempt to reserve some of that, but I will let you proceed in whatever way you've decided to proceed.
Thank you. Your Honor, I'll be taking the first 10 minutes. We're going to split it evenly.
Okay, sounds great. Thank you.
Thanks. May I begin?
You may, please. Thank you.
Thank you. May it please this honorable court. I will try to save 2 minutes for rebuttal. Alona Sharon on behalf of the appellant, Clifford McKee. The trial court erred where it denied Clifford McKee's motion for mistrial after it admitted Cortez Butler's statements that detailed previous murders that he had committed, murderous activity, and his work as a hired gun for drug dealers. Admissibility of Butler's statements regarding his prior bad acts and the prior bad acts themselves were litigated prior to trial. Prior to trial, Judge Wilson had concluded that admission of this evidence would unquestionably deny Clifford McKee a fair trial. The trial court, whether it be during the pretrial phase or during the trial, never wavered in its legal conclusion as to the prejudicial nature of this evidence. But upon hearing news that Cortez Butler may choose to testify at trial, Judge Wilson recognized the impossible dilemma that he now faced. The prosecution sought to impeach Butler with this damaging evidence, but this, of course, was the same prejudicial evidence that he knew would deprive Clifford McKee of a fair trial. Despite the court's firm belief as to the prejudicial nature of this evidence, he chose to favor judicial economy and instead opted to provide a cautionary jury instruction rather than grant the request for mistrial. The court's decision was insufficient to protect Mr. McKee's right to a fair trial. While there is a presumption that jurors follow their instructions, it is just that, only a presumption. There will be circumstances in which the nature of the evidence is so prejudicial that the presumption is overcome. There are scenarios in which the mental gymnastics of asking jurors to forget horribly damaging testimony is simply impossible. And this is a fact that this honorable court must recognize. The Court of Appeals rejected Mr. McKee's argument in part because it concluded that he did not demonstrate the prejudice necessary to reverse the trial court's joinder decision, but the court got it wrong. Courts, including the United States Supreme Court, have reversed in some cases, recognizing that the evidence was so prejudicial that a limiting instruction was ineffective. Clifford McKee's case is such a case. I'd now invite the court for questions.
Thank you, counsel. I'll start with Justice Bernstein.
I don't have any questions at this time. Thank you.
Justice Clement.
Not at this time.
Justice Cavanagh.
I do. Counsel, I'm wondering if you can help me. So let's say that we agree that Mr. Butler testifying removed the confrontation problem and therefore removes it from the severance analysis that we focused our MOA order on. I'm a little bit troubled by the fact, I'm wondering what you can tell me about this is, the Court of Appeals held that Mr. Butler's confession was inadmissible because it was involuntary. And the Court of Appeals harmlessness analysis was understandably all focused on Mr. Butler's other evidence of guilt, but that wouldn't apply to the McKees. So I guess I'm wondering, but for our MOA order, is the admissibility of the involuntary confession against the McKees, is that before us sort of independent of the severance issue that we have identified?
So respectfully, Justice Cavanagh, I did not read the order from the court to address the confrontation issue because Butler testified, I don't think that there is a ripe Bruton issue for Clifford and Rodney McKee. Until the point that he did testify, I do think they would have had a valid Bruton claim. But once he chose to take the stand, I think that Bruton claim was extinguished. So I didn't take the order as wanting to address a Bruton claim because I didn't really think there was a valid Bruton claim for Clifford and Rodney McKee, and certainly because I don't think Bruton was cited in the order from the court. What I took the order more to want to address was whether or not the admission of his statements, once the prosecutor was able to cross-examine him, whether that was the court should have granted the request for mistrial that came subsequent to Cortez Butler's testimony. I'm not sure if that's responsive to your question.
Okay, no, I appreciate it.
Justice Welch?
No question.
Justice Zahra?
No questions, thank you.
Justice Viviano?
No questions.
All right, you may continue or you may let Mr. Halpern jump in here, up to you.
I think I'll reserve my remaining time then, Your Honor, and allow Mr. Halpern to begin.
That makes sense. Okay, Mr. Halpern?
Morning, everybody. At the trial, we all know that, of course, Rodney McKee, attorney, moves for a separate trial. And of course, the court rules this so wrongfully that that Butler's statements is coming in as substantive evidence against Rodney McKee, and says, of course, that Butler's prior bad acts would not. That last part changed a little bit when he allowed one. He opened the door. He allowed one prior bad acts, one murder. And of course, the rest of them came in after that, give a finger. In any event, what happens is that the motion by, I'll call him Rodney, if I may, the motion by Rodney's attorney was absolutely correct. But incorrect was that he didn't in any manner even attempt to do an application for leave to appeal interlocutory, and that really was incorrect. The Court of Appeals, after ruling correctly that the statement that came in with Merritt and Sullivan was inadmissible, doesn't have any exceptions to the hearsay. What they failed to do is to apply that ruling. As Justice Cavanagh just said a few minutes ago, and asked a question about it, and that is that they did no cumulative analysis whatsoever after making that correct ruling that the statement was not admissible as substantive evidence. They simply separated it and decided to go on what they must have believed was an entirely different issue, and they were wrong. The ruling and about Bruton, I mean, this is not nothing about Bruton. Bruton and its progeny are all about a situation where the judge instructs the jury on multiple defendants, where they said, look, this confession is only applicable to number one. And of course, they redact it. There was nothing really brutal about this whole situation. There was no redaction here, zero. Not only there was no redaction, they added to it. I mean, the officers, both officers told them, hey, that's Rodney. The prosecutor points him out. And in fact, I realize we're just dealing with words, but she clearly says, oh, you must have lost some weight. So she's pointing him out to the jury. And in fact, the prosecutor not only vouches for her officers, but she, in fact, cleverly but wrongly, which is one of the reasons an issue of prosecutorial misconduct was raised, which is not before your honors.
Mr. Halpern, let me interrupt you and see if anybody has questions for you at this point. Okay, that's, I think, Justice Bernstein?
No questions at this time.
Justice Clement?
Not at this time.
Justice Cavanagh?
Not for me.
Justice Welch?
No questions.
Justice Zahra?
No questions.
Justice Viviano?
Hello, Mr. Halpern. I have no questions. Thank you.
Mr. Halpern, do you want to continue or do you want to reserve your time for rebuttal that you and Ms. Sharon can decide to use how you like? Are you
continuing only for a moment?
okay?
I continue because I want to indicate that in the 62 years that I've been doing this, I have never represented someone who has been so involved in his own appeal and who has done such an excellent job. I received a number of JPAYs, as they say, and he points out, I would say at least a half a dozen points that got me going, and I commend him for it. Compounding the prejudice and unfairness, because if you do the analysis, there's nothing left. I mean, what we have here, I think, three things: text messages about a landscaper and a mechanic between Rodney and Clifford. Rodney received a check from the city, and Rodney McKee spends a lot of time in Jackson, where he happens to live. Not only that, but the reason I mentioned my client in that light was because he did point out that not only, obviously, we all know that this incriminating references would be speculative, specious, but as he points out, there's no foundation on which to establish any probative value for that evidence. So it wouldn't even come in at all. In any event, I wanted to add that because, as I say, I feel that he should be commended. In fact, he was asking whether or not he could do part of the closing argument, and I said, I'm afraid not. Thank you.
We don't have closing arguments in the Supreme Court. Let me just ask you, I'm a little bit taken aback. Both you and your co-counsel have said this isn't a Bruton case, but your briefs have Bruton all over it. I mean, is this a Bruton case or isn't it?
It's beyond Bruton.
Well, help me understand what that means.
Cases dealing with Bruton, as I pointed out, and as your honors, I'm sure know, I mean, the case is where a judge instructs that a confession only applies to the confessor. This was not it. This was saying whatever he says in there. And in fact, the prosecutor here improperly not only vouches, but says the judge vouches too. She says, hey, this would never come in. Never. This would never come in if there was anything amiss, is her words, if I remember right. If there was anything amiss, you wouldn't have even heard this. So she now has the judge vouching for this. It's beyond a Bruton situation. There's no instructions. There's no limitation.
Totally.
Here it is. It's substantive. That's how I say it's unlike.
All right, thank you. Thank you.
Thank you. Thank you.
Thank you. I will, you all can reserve your time. Mr. Way. Mr. Way,
Thank you, Your Honor.
before you begin, your video is somewhat blurry. I don't know if it's supposed to just be your background, but we're having a hard time, if you care, seeing your face as well.
Okay, I apologize for that. I don't know if I can change that in this meeting.
Can you get closer to the camera?
Yeah, that's a
that
little
better?
better. Yeah, it's a little better.
Maybe.
Mhm.
Okay, I apologize for that. Good morning. May it please the court, Matthew Wade, P77286 on behalf of the plaintiff. As the court's aware, Mr. Jerry Scrotenbohr wrote the brief on behalf of the people. He has since retired, so I'm going to do my very best to do him justice here today. While this court did not grant leave on the issue, I guess, of severance per se, I think the analysis of what we're dealing with here today is basically a severance argument. Evidence came in that may not have come in if separate trials occurred, and Clifford and Rodney McKee contend that they were entitled to mistrials as a result of that. I interpreted the court's order, as did Mr. Scrotenbohr, the same way that Ms. Sharon did. I would just note, in response to Justice Clement's point or her question, that I do believe the Court of Appeals analysis should be the same in terms of the involuntary statement, because the evidence against the McKees is the same as the evidence against the Butlers, against Mr. Butler. It's based on this phone data. It's based on phone messages and a collection of, or the context of the prior arson and all that leads up to this. So the evidence is the same, and I think the analysis should be the same, and I think the Court of Appeals clearly came to the correct decision there. Given the severance issue, I think it's important to look at the factors that we do look at when determining whether severance should take place. And I think when you look at all those factors, the complexity of the case, the right to present an individual defense, the fact that the McKees were not implicated in the involvement, Mr. Butler's involvement in these prior homicides, and the theory that the McKees were more aiders and abettors or solicited this. I think those all weigh in favor of the defendants having received a fair trial. At this point, I'm open to take any questions, and if there aren't any, I can continue with my argument.
Thank you, Mr. Way. Let's see, Justice Bernstein.
I have no questions at this point. Well, actually, I just have one question. And counsel, first off, thank you for your argument. I guess my question is, again, I kind of have a theme that I tend to operate under, that you just try to keep things as simple as you can because it tends to make the most amount of sense. And, based on what Sister Counsel said at the beginning of the arguments, I mean, if you look at this situation, if you look at kind of what happened, if you look at kind of how the players have kind of interacted, isn't it difficult to kind of come back after the kind of statements and testimony that was given?
I guess I'm not quite understanding the question. Come back in terms of what?
Come back, like for example, like when you have a co-defendant that's basically saying the certain things that they're saying, just from a commonsensical approach, it's I'm just thinking of it from this perspective, isn't it somewhat difficult to be able to put on like a really stellar defense when you're dealing with another defendant that is basically kind of making it very tough for you to put on your own defense?
I think it's difficult.
And you're part of the same, and you're kind of in the same trial. Like it's all, it just seems like it's rife for a situation where, just from a common sense perspective, how does one navigate through that?
Sure, I think it's more difficult certainly than if you have your own trial and there,
Right.
you know, there's certainly nothing I can argue against that. And I think what the defense's argument in this amounts to is that it made acquittal more difficult than it would have been if they all had separate trials. And that's not the standard. The standard should be whether they were so unfairly prejudiced that they couldn't get a fair trial to begin with. And the fact, I think, that their defenses all lined up, they all just simply said, we didn't do this. So I don't think it actually impaired their defense, even if there was some sort of prejudicial testimony that came in. All of the testimony that comes in is prejudicial. That's the nature of the system, but I don't think it was
prejudicial from, I mean, I guess, no, what I'm just trying to understand, and I get the complications of this and, you know, the general conception of this, but it's prejudicial. But I guess my concern is that it's coming from a person that you're on trial with. So it's just kind of, it just seems like, I understand the standard, and it just seems like in this situation, you know, the burden seems to be very extensive.
I agree to an extent. And I think one of the things that Judge Wilson did very well during the trial was that he excluded a lot of evidence that I think would have made this even more problematic. And the most specific one, I think, is that Clifford, McKee, and Mr. Butler, there was evidence, there was going to be testimony. It was requested by the prosecutor that they present evidence that the two of them knew each other from prison, that they were serving sentences together on homicides. If that would have come in, I think the combination of all those things, that would have been hard for the jury to ignore. But I think given all the other evidence that was presented that was legally admissible and what was excluded, I do think that they had the right to present a fair defense, and I think their right to a fair trial was allowed in this case.
Counsel, thank you very much.
Thank you.
Thank you. Justice Clement?
No questions right now. Thank you.
Justice Cavanagh?
I guess I want to ask you similarly to what I asked Ms. Sharon about. I'm troubled by I understand you saying that, you know, that it was sort of harmless. The evidence against the overwhelming evidence of Mr. Butler's guilt was the same as with the McKee. So even if it wasn't the involuntary confession of Mr. Butler shouldn't have been admissible against the McKees, there was really no harm. But my question is, and I get that argument, and maybe that is true, maybe it's debatable, but we don't really have, because our question didn't really get to that, we don't really have that addressed here in this MOA. And so I'm wondering if you think there's a need, or it would be wise to have supplemental briefing on this question of the admissibility of the involuntary confession. And I understand your argument of saying, well, even if it was an error, it would have been harmless because the guilt of, or the other evidence of McKee's guilt was sufficient to overcome any error.
Sure. I mean, I would be happy to provide a supplemental brief. I do think, though, that the evidence, if you take out that statement, that the evidence is still the same, even if you did separate trials, all of the evidence that the Court of Appeals considered as it relates to Mr. Butler, even taking away this involuntary statement, is all evidence that would have come in as to the McKees. So I do believe the analysis is the same, but if the court feels that it needs to be briefed in further detail, I certainly would be happy to do that.
Okay, thank you.
Justice Welch?
No questions.
Justice Zahra?
Thank you.
Justice Viviano?
No questions.
Okay, counsel, you may continue if you have more argument.
Thank you, Your Honor. I just want to know a few more things. You know, this case, it began with a very complicated investigation. There was a lot of complex motion practice, certainly. But the facts that were presented to the jury were quite straightforward, I think. And that was in part because of Judge Wilson's proper use of his discretion in both admitting and limiting evidence. And the fact that the case was so straightforward and the facts that were presented to the jury certainly weighs in favor of Mr. and Mr. McKee having received a fair trial. There was never any suggestion as it relates to Mr. Butler's prior involvement with homicides that either Clifford or Rodney McKee were involved with that. And I understand and I admit there's an argument to be made, well, you know, that means it's not relevant to them. But the fact that it's not relevant to them is the reason that it's not overly prejudicial. And Judge Wilson gave a very specific, in fact, multiple specific limiting instructions regarding that. And the fact that this case was so simple in its facts, I think allowed the jury to compartmentalize this rather easily and follow that instruction. There's been no showing that the presumption that juries follow their instructions wasn't the case in here. I did also just want to point out, because I don't believe Mr. Scrumbore addressed it in his brief, is the Rode and Galena cases, which are the companion cases to Hannah, because I think those are very similar to what we have here. A co-defendant who the prosecution alleged was the actual person who committed the murder. And there were multiple juries in this case, but he ended up waiving his Fifth Amendment right. He's eventually questioned by the prosecution. Impeachment evidence comes in that probably wouldn't have been brought in probably wouldn't have been brought in if he didn't testify. But this court held that the risk of prejudice was lessened because in part, the other co-defendant, the theory of the prosecutor was that they were an aider and abetter. And that's precisely what we have here. There were two juries in that case, but the effect of how the testimony came in is the same. Even if we had 2 or 3 juries here, Mr. Butler's case would have been presented first and the result and the analysis ends up being the same. And I would note in those cases, Rode and Galena, those co-defendants actually had antagonistic defenses. That's not what we have here. Here, the defenses were identical. Ultimately, like I said, the defendant's arguments, I think, amount to the fact that they would have just had a better chance of acquittal if these statements hadn't come in. But that isn't and shouldn't be the standard. The standard should be whether the evidence so unfairly prejudiced them that they couldn't receive a fair trial. And that's not what happened. Ultimately, this jury convicted both Clifford and Rodney McKee based on the mountain of legally admissible evidence that tied them to the murder of Francis Craig. And if you have no further questions, that would complete my presentation.
Thank you, counsel. Let me see if there are further questions. Anybody have additional questions for Mr. Way? All right, Ms. Sharon, Mr. Halpern, you have some rebuttal time.
Thank you, Your Honor. I'll use my remaining rebuttal now first. Thank you. I would like to address first Justice Zahra's question about my position that it's not a Bruton case, yet Bruton is peppered throughout my brief. So I don't believe that it's a Bruton case in the sense that you don't have a situation where a co-defendant statement is used without the co-defendant testifying, right? Because Cortez Butler does ultimately testify at trial. Bruton is used within my brief for the proposition that a cautionary limiting instruction is not always going to be sufficient depending on the prejudicial nature of the evidence, right? That is sort of a principle that comes out of Bruton. It's a principle from Bruton that Chief Justice McCormick cited in her, I think it's your Bruner opinion from a couple of years ago. And I think that that's a principle that the court has to recognize that in certain factual scenarios, limiting cautionary instructions are not going to be sufficient. So to that extent, Bruton is peppered throughout the brief. Mr. Way talked about that this is an issue really revolving around severance, and I do kind of want to talk about that. So in MCR 6.121, right, if a defendant seeks severance, he would have to offer an affidavit or an offer of proof of what type of prejudice he thinks will come to him if there's going to be a joint trial. It's funny because chronologically, the need for that motion is almost sort of cut off by the prosecution's motion. I think it was entitled Motion to Admit Evidence in this case, right? They file a motion wanting to admit Cortez Butler's prior bad acts, statements about these prior bad acts, and Judge Wilson rules in their favor, right? In the defense favor, saying this evidence isn't going to come in. It's far too prejudicial for the McKees. And the defense ultimately does file a motion for severance, but based on an anticipated Bruton issue because no one ever thinks Cortez Butler is going to testify. What's interesting though, right, is that if Clifford McKee had filed a motion seeking severance, that this evidence regarding Cortez Butler's prior bad acts would prejudice him, right? That's what would go in the affidavit, right? This is going to prejudice me because if Cortez Butler testifies, all this horrible evidence is going to come in. And Judge Wilson recognized this is horribly prejudicial evidence and it shouldn't come in and we're not going to let it in. And then when they ultimately get to trial, all this horribly prejudicial evidence ultimately comes in, right? And a defendant on a motion, on an appeal, when it comes to a severance issue, is only going to be successful if he can demonstrate that the prejudice he anticipated actually happened. Well, here, it's just that the prejudice that the court anticipated actually happened. And it just happens that chronologically, the court gave the defense the ruling on the prosecution's motion to admit evidence. And I think that that's really important for this court to recognize, right? Judge Wilson never wavered in his legal conclusion that this evidence about Cortez Butler would prejudice Clifford McKee. And despite that fact, somehow a cautionary instruction is supposed to just pluck this evidence out of the minds of jurors. And it is an unreasonable expectation. And our courts have recognized that. And language from Hannah and Zafiro recognizes that when this type of evidence, prejudicial evidence against one defendant that wouldn't be admissible or properly considered against a co-defendant, that's going to lead to the type of prejudice that should give Clifford McKee a new trial. Also, I want to just address Justice Cavanagh. I think you asked a question of Mr. Way about whether or not there should be supplemental briefing regarding the statement and how it was used. I would respectfully, very strongly disagree with Mr. Way that had Cortez Butler's, and I think you're asking about his confession, had it not been able to be used against Clifford McKee, would there have been sufficient evidence against Clifford McKee? And I would strongly argue that there would have been woefully insufficient evidence to convict Clifford McKee, because at that point, all you had was text messages or text message phone records showing that they traveled together on a day, not the day of the murder, and that they texted each other. Okay, so, I mean, that's really probative of nothing. So if the court has some questions, I'm happy to. Oh, I do want to make one other point. The court talks about, and the prosecution noted in their case about, right, incidental spillover, that's not going to warrant a new trial, right? This is an incidental spillover, what happened in this case, right? The definition of incidental is by chance or without intention. This evidence, this damaging prejudicial evidence, was very much intentional, and it certainly wasn't by chance, right? It goes, and it's not fleeting. It goes on for pages and pages and pages, culminating with Madam Prosecutor saying to Cortez Butler, I think we've talked enough about murder today. How is that not prejudicial to Clifford McKee?
Stopping talking right when the clock hits zero. Very
I'm
well
trying.
done.
Justice McCormick, it's my first time here. I don't want to get yelled at.
You've done an excellent job. Are there additional questions for Ms. Sharon or Mr. Halpern? Okay, thank you all. The case will be submitted.
Your Honor, may I have a moment? I would like to input. I thought that Ms. Sharon inputted, and I would like to.
Mr. Halpern.
I'll be 2 minutes, a minute.
Mr. Halpern, the time is gone, but Ms. Sharon did an excellent job on behalf of both defendants. So rest assured, you did too. And we are happy to have heard from both of you. Thank you very much. The case will be submitted.